Good afternoon, everyone. Allison Schaberg here, Consolidated Planning Group. We are super happy to be here today with Hope for Three and also Hayes and Wilson, Bill Hayes from Hayes and Wilson. So we're going to get started today just with a little housekeeping items. Today we are in webinar mode, and that means that we can't see you or hear you, but we do know you're here, and we're glad that you're here and that you've joined us today. If you're planning your time, we're going for an hour today. We will be done within an hour. We invite everybody to put their questions in the chat box, and we'll get to as many questions as we can during the time that we have together today. But first, I'd like to start off with Rowena from Hope for Three. And Rowena, I know we've partnered with Hope for Three a lot in the past, and you guys are doing big things in the autism community. Tell us a little bit more about Hope for Three and what you guys are up to.
All right. Thank you, everybody, for joining. And thank you, Allison and Bill, for the great company for today's webinar. Hope for Three, as some of you might not know, we are located in Fort Bend County, but we serve the autism community at large. What that means is that all our events, information, resource, um, details and things like that is open to everybody in the autism journey. However, we do have a special program that we do provide financial assistance within the Fort Bend County area. However, if you're not in that location, we could absolutely direct you to the proper resource. As a nonprofit serving the autism community, we serve from diagnosis to adulthood, as we understand that these gifts our loved ones have, they're going to be with that for a long term. We have events that are free to our public, as well as community gatherings, empowerment, and education just to strengthen our community. We invite you to visit our website and follow us on social media for additional questions. We are great. We are here to help and look forward to meeting with all of you. And thanks again for including us today.
I also just wanted to mention the Teen Huddle. One of my kids participated in the Teen Huddle, and this is a very great way to get some of the volunteer hours that they need in high school. So check out the Teen Huddle, check out some of the various programs. Their website is awesome. They're doing a lot of things in the community, lots of events. There's, parent night out things that you can
Mhm.
participate in as well. So definitely get involved. And thank you for doing all that you're doing that. Hope for Three was founded years ago, and it was a family. They had triplets, right, with autism.
Correct.
And so that was kind of the basis and the whenever it was founded, and it has just grown and grown and grown. So you guys are really doing awesome things. So thank you for that, Rowena, and we're so glad to be back with you. So for those of you that are joining for the first time, Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy, and certified in special needs. Our whole firm is nuanced in planning for special needs, but we don't do what Bill Hayes does or what his firm does. And there's always often a lot of confusion on what we do and what the attorneys do when it comes to your legal documents or discussions like we're talking about today, such as guardianship. So I always shorten it, Bill, and I say that you guys are the paper and we're the money. How much money do I need to fund the special needs trust? When and how should I pull the trigger on public benefits? How do I maintain those benefits and that type of thing? So when it comes to planning for special needs, there are multiple people that you need at the table. One is the financial planning team on the special needs side. One is your legal team, and I would argue, and I argue this all the time, Bill, that it is really, really important to work with a firm that is nuanced with special needs. Your neighbor next door that's going to do it for free, that's a real estate attorney, just say no. You really want to work with a specialist when it comes to your documents, when it comes to planning for a loved one with a disability. I think it's truly, truly important. So, one of the things that I would like to mention is that, when it comes to planning and the additional people at the table, so you've got the legal team that is nuanced in special needs, you've got the financial planning team, nuanced in special needs. And oftentimes there's also, CPAs involved. And just like the specialty of that, we have a lot of CPAs that we work with. I wouldn't say a lot. We have a handful of CPAs that we know are specifically nuanced and understanding the taxation of the special needs trust and things like that. So when it comes to the people at the table, you want to make sure that you've got the right people in the right seats at your table when it comes to planning. So whether you work with us, or you work with Hayes and Wilson, or you work with somebody else, you just really want some specialists on your team when it comes to that. So when it comes to special needs planning, we do protection plans, lifetime care plans, transition planning, ABLE accounts, and we do a lot of advocacy by way of webinars. So I am a parent myself to kids with disabilities, adult kids with disabilities, and what I found is that all of this is hard. Even though I know this and I eat, sleep, and breathe this, when it comes to planning and making sure that you're doing the right things, crossing the T's, dotting the I's, and more importantly, not doing what you're not supposed to do to mess things up, it felt pretty overwhelming to me. So the Consolidated Planning Group YouTube channel and our series of webinars was born from that, and mainly because we want to empower you as a parent to have the tools and resources that you need to be successful when it comes to planning for your kid. We don't want you to feel overwhelmed. We want you to feel empowered and feel like you know what you need to do to take the next steps to be successful. So having said that, I almost feel like Hayes and Wilson doesn't need any introduction in the greater Houston area. They've been around forever. You guys have heard names of Bill Hayes, Lisa Wilson, Julia Hayes. Those are all people at their firm that we've worked with and referred to for years. They are well known in this community for doing a great job when it comes to planning for special needs and all of your estate planning documents, your special needs trust, these discussions and guardianship, which we're going to be talking about today. So Bill, we're going to have you take it away. Welcome. Tell us a little bit more about yourself and your firm, and we're going to run with this.
Sure. Hayes and Wilson was actually founded in 2007. Lisa Wilson and myself. Julia Hayes came along and joined us about 12 years ago. Even though we have a common Irish surname, we're actually not related. Her father is Bill Hayes, who's a lawyer in a different law firm, although he's retired now. But so there's a lot of William Hayeses that are attorneys, but we're the three primary. And then we've just hired some new attorneys, Masha Pobedinsky, Louisa King. I'm planning to step back in the near future to less than half time and be of counsel to the firm. Lisa is the one who really got all this started off in the special needs arena. She was happily an award-winning writer for Texas Monthly. And when her third child was born with Down syndrome, she's like, oops, now it's time to become a lawyer and make more money and to move to a location with better special needs. And so she's been geared towards special needs planning her entire legal career. I came to it a little bit late because my daughter was okay until age 18, and then she suffered a devastating brain injury when she was in college. And so I came to it a little bit differently. Guardianship is something that's interesting. Guardianship is sort of the ultimate default for how you step into someone else's life, like that of a child, and to manage income and assets on their behalf or to make personal decisions for them, like who their doctors are, things like that. It's the big gorilla that if nothing else is working, this is what you do. In our case, however, I didn't have to get guardianship on Emily. Our mother and I didn't get guardianship on her until she was 43 years old because there was no need to. We never ran into an issue that couldn't be handled without the necessity of guardianship. But Emily was going residential with the Brookwood community, and Brookwood has changed their policies to require guardianship on all of their residents. And so that's why we finally got guardianship on Emily last year. So when your child turns 18, that's when up until age 18, as the parents, you are their natural guardians, making decisions for them. When they turn 18, theoretically, they're an adult and they're on their own legally. And so that's when we would consider guardianship and whether that's really necessary. If we don't do guardianship, for instance, when your child goes to the doctor, there's some question of, do they really have the capacity to make their own decisions? Are they making good decisions? Do they need help making those decisions? Does someone else make those decisions for them? And so guardianship is one tool. As I say, it's sort of the ultimate default. But I believe on the next slide, we may have some alternatives to guardianship. Well, guardianship itself, it's just a legal relationship where the guardian is making decisions for another person, the ward, due to the word's lack of capacity. Now, guardianship can be a total, complete guardianship that they don't have the capacity to do hardly anything, or it can be partial for all of their activities of daily living and their living arrangements and a lot of personal decisions. They still have enough capacity, but on making complex decisions, financial decisions, that would be beyond their ability. And so guardianships can be partial or total if they're required. On the next slide.
I just have a question. If I want to
Sure.
say something for here for a second, because it's one thing that we hear this and we talk about these kind of things all day, every day. You guys, this is what you guys do, but sometimes guardianship feels a little scary, and
Yeah,
then in Texas it's the least restrictive, most appropriate for the ward, and you're going to talk about that.
right.
I like to share with families that you don't have to know what you need when you go to sit down with an attorney, because your job, you're going to talk to the individual, you're going to talk to the parents, and you are going to flush out what is the least restrictive, most appropriate. They don't have to have a be all end all, this is what I've decided I'm doing when they come to sit down with you. In fact, even if they have decided they're doing something, it might not be the least restrictive, most appropriate. So basically, I guess what I'm saying is, attorneys, you guys are going to sit down with somebody and flush that out and discuss it. Discuss the strong points or the weak points of the various options, and then together come up with what might be the most appropriate solution for the individual. Is that correct?
That's correct. And as I believe one of these slides is going to say, guardianship is predicated on incapacity. Incapacity in these terms means that the individual, minor or an adult, due to physical or mental conditions, substantially unable to provide for their own needs, to care for their own health, or to manage their own financial powers. But it all turns on medical evidence. The predicate for any guardianship is to get a doctor's letter. Here in Harris County and in Texas generally, there's a standard 4-page medical evaluation that is prepared by a doctor who has visited with the proposed ward and has evaluated them for guardianship purposes, and actually goes through and slices and dices their life as to what do they have capacity to do or not do. That's the starting point for anything. So before we even sign up a client to prepare guardianship for their child or an adult, we ask them to go and get the doctor's letter first and see whether the doctor agrees that there is incapacity and that there's a need. Or does this person have the ability to sign powers of attorney and healthcare power of attorney and financial power of attorney, which would be a less restrictive alternative to the guardianship? Can they sign a supported decision-making agreement where the agent is authorized? It's kind of like a financial HIPAA. The agent is authorized to go and gather information with the view of helping the individual make decisions as opposed to making those decisions for them. If they were acting under as an agent under a power of attorney, they can just make the decisions without input from the ward necessarily. But if it's a supported decision-making agreement, now we're helping the individual make their own decisions by gathering the information, organizing it, helping them reason through it.
I just want to say that the supported decision-making agreement is definitely a thing in Texas. Not all states have supported decision-making agreements. We do have people that attend from out of state. We call it guardianship. Some states call it conservatorship or other things like that. But I wanted to ask you a question before we move on to the types of guardianship, about capacity. In the special needs community, the IDD, intellectual developmental disability, is thrown around a lot. That's something that we hear all the time. IDD, and in general, the general thought process is an IQ of 70 or below. Is
right?
there a magic number that you, as an attorney, if a person has an IQ, say their IQ is 70 or below, say it's 65, does that lend itself that it may be more appropriate for something more restrictive like a partial guardianship or a guardianship? Or is there a number in particular that's
There's
a line in the sand?
No, there's no specific number that's a line in the sand. And whether the guardianship is going to be partial or total, if it's partial, what rights are being impacted, that all turns on what the medical evidence says. And so, in that regard, uh, I don't really get a vote on what rights this person keeps or doesn't keep, nor does the parents, because it's all going to turn on the medical evidence. And if the doctor has said that this person doesn't have the right, doesn't have the capacity to make informed decisions when they're driving a vehicle or voting or the right to marry or something like that, the court is not going to allow them to retain those rights. Now, how many rights or what bundle of rights, if any, the ward retains is not static. We can go back and revisit this from time to time. I had a case just this last year where in 2017, a domestic argument resulted in a man getting beat over the head with a baseball bat. We thought he was going to die. He went into a total guardianship with his brother taking care of him. We actually got him completely restored with all of his rights last summer because he had made such good progress on recovery. We even got him restored to the right to possess a firearm. And so he was completely out of the guardianship system then. We've had other cases like that where wards have progressed to the ability in their abilities and in their capacity, and the guardianship was no longer necessary. So it's not a static one and done. This can be reviewed at any time in the future, depending on circumstances.
And I've also seen some where seen some guardianship in place where there is like serious mental health challenges in place, and the person may not have an intellectual disability at all, but they have mental health challenges. So everybody's situation is different and unique, and that's the important thing. Is I think I just want to encourage of not to be afraid to have the conversations and to talk to a professional, talk to your physicians. And it's not, like you said, one and done. It's not forever, and it can be changed. And a lot of times what I've seen where a person that maybe does have an intellectual disability or doesn't have the ability to be their own guardian at age 18, that might be very different at age 35.
Yes,
It might be very different at age 30. So things do change. Thanks for sharing that.
sure. As the screen, the language on the screen currently says, guardianships are two varieties. There's guardian of the person making personal decisions. Where do they reside? Who are their doctors? What are their personal privileges? We've had situations where we've had to restrict mail and phone privileges because of various issues. But it's taking care of the individual. Guardian of the estate is managing their income and assets on their behalf in their best interest. Now, guardian of the person is not a big deal. I mean, it is a big deal that you're responsible for this individual, but in terms of ongoing court involvement, you just file one report at the end of each year that says how the ward is doing. Where are they? How's their well-being? What's their condition? Has there been any progress made? What has changed with this individual, and does this guardianship need to continue? Guardian of the estate is quite different. Guardian of the estate, you can't spend any of the ward's money without getting prior permission. And you have to keep receipts and report everything at the end of the year with receipts to the penny. And the guardianship accountings that we have to prepare on for these are not like any kind of accounting you've ever seen before. We've got one paralegal that's all she does is prepare guardianship accountings. And it keeps her full-time busy because basically you have to keep a shoebox of everything, and then we have to categorize it and sort it and put it in the format that the court wants at the end of each year. Now, there are alternatives to being guardian of the estate, which I think are on maybe the next slide.
Can you tell us about the guardianship of the person? Sometimes I've had clients that have come to me and said, we're really worried about doing this guardianship of the person. Our child is violent. If they do something terrible, are we going to be arrested for this? So I think that there's some misnomers out there that make people feel afraid. Can you talk about that?
Sure. And the quick answer is you do not have liability for what your child does, or your ward does. We would expect you to, make appropriate living arrangements for your ward. If your ward is violent, are they in an appropriate facility? Is it a secure facility? Things like that. But even then, you're not going to have personal liability if they hop the fence and do something stupid. That's on them. You're there to help and assist and provide for them, but you're not responsible for their actions in that sense. So I wouldn't hesitate to be a guardian of a person. And I've actually taken on guardian of the person for several wards over the years. It's always been a very interesting experience. Interestingly, a guardian of the person, you do not have the ability to involuntarily commit your ward. You still have to go through the Harris County psychiatric process of going down to 288 and McGregor and swearing out an affidavit of personal knowledge and going through the mental health process. And then you can get your ward into a mental health facility where they are committed. Uh, but that's a pretty rare occasion. I did have one elderly lady who got messed up on her medications and got some UTIs and became very violent and was hitting caregivers in the head with the little dumbbells. And we had to get her committed to a geriatric psych ward to straighten out all of her medications. But that's a separate process. Guardians just by themselves don't necessarily have that ability. Now, I'll tell you that a lot of the dementia facilities that exist in town are sort of in a gray area that if you get your loved one there and they lock the door, they don't let them out. Now, you haven't actually committed them through a court process, uh, but the facilities get it and they don't open the door and they hang on to them and they do what they're supposed to do of keeping your person safe and off the street. Even though you haven't gone through any kind of involuntary commitment process, they're still in a facility where they can't wander. This is very common with elderly patients that have dementia, Alzheimer's, things like that. And so again, it's not a court proceeding, but it is a lockdown facility where they can't wander. But being guardian of the person, it's really, kind of like what any parent would do for their child. And just as when your child turns 18 or 20 and they are in a car accident, you're not responsible. Maybe through the insurance you are, but you're not personally responsible because you don't have control of their actions.
We have a few questions in the chat
Sure.
box. But you said something that I want to hit on before we go to these questions. You said that you've been guardianship of the person for other people. You know,
Mhm.
sometimes, several times a year, I am contacted by a parent that says, "It's me. It's only me. There's nobody else. When I'm
Yeah.
gone, there's nobody else to be guardian." And a lot of people feel a lot of panic about that. So is Hayes and Wilson specifically a firm that would take on guardianship of the person or be a successor guardian in the event that there's nobody at the end of the line?
Possibly. I have been more willing to do that than my partners, and it is sort of a attorney by attorney decision whether they're willing to take on that responsibility. And I'm actually getting close to retirement, so I would probably not be taking on a new guardianship at this point. I'm not sure if we would just have to talk with the other attorneys and talk about the specific situation, whether they would be willing to do it or not. We wouldn't rule it out, but it's not something that we covet or that we seek out. Usually there's somebody within the family or the family friends that's better situated than a stranger attorney. um, but again, it depends on the circumstances. It also depends on whether there's an estate that we can get paid. I mean, that's always a
Right.
consideration.
It's not free.
How does that
Right.
work?
Yeah.
Yeah.
And now I do know that some places, and I'm not going to name names like of residential living places, sometimes they'll take on guardianship of the person, like if they're living at some of these residential places, sometimes they will do that, but it is a case by case basis, so you're gonna, if I definitely know that there's people, and they're already in the chat box saying that there is nobody else, that, you know, we run into this all the time. So the main thing is talk to the attorney firm that you're working with, make sure it is, you know, nuanced and special needs. Check with Hayes and Wilson if you don't have somebody else. That would be important. So one person says when it comes to like the evaluation, would an evaluation by a LIDA like Texana or the Harris Center, like a psychologist, be enough? Or mainly you're looking for this doctor, this physician statement?
We're looking for the doctor's evaluation. It can be by any doctor who has recently visited with and examined the individual. They don't have to be their continuing primary doctor. It's any doctor can do that. And so if they go to Texana or one of these others, there just has to be a doctor there that's willing to um, fill out the form. Not all doctors are willing to do it. We've run into some gerontologists and others involved with that they don't want to do it because they see establishing a guardianship on their ward on their patient as contrary to what they're trying to do, which is cure them or improve them or something.
I've seen a lot more of this in the last 5 years, and I wonder if they go to some CE and they have warned them about signing off on guardianship or something, because it seems like it's just been a lot more lately. So one person asked, is guardianship something that we can do on our own, or do we have to have an attorney? What if we can't afford it? And I always preface, what if you can't afford it? You know, Disability
Sure.
Rights Texas, there's legal aid. You can go to Google and type legal aid and put in your county, put in your town, and the legal aid associations in your area will pop up, and you can call and talk to them about discounted or free services. Those are for low income. So there are options that way, but I'm not aware of people being able to do guardianship on their own, can they?
No, it's not, because the guardian is a legal capacity. So William Hayes individual is different than William Hayes guardian. And so you're going into court to establish a guardianship on behalf of a father to take care of his daughter. And the actions to represent father are the practice of law. So you have to have an attorney involved. So that's where that rule comes in. But yes, guardianships require the involvement of attorneys, and not just any attorney. They changed the rules about 4 years ago that attorneys who practice in this area have to go and do a little bit of additional training to get a guardianship certification.
And so one person asked about medical doctor or psychologist. So these physicians, it needs to be an MD or a DO. None of this licensed clinical social worker does the job. It has to be an MD or a DO, a psychologist, a psychiatrist, the doctor. Those are all people that can sign off on the physician statement. Is that correct?
Correct.
Okay, awesome. And then I don't know if you have any knowledge about this, or if you would rather they follow up with Brookwood. Somebody asked, will Brookwood take on the role as a guardian when parent dies?
I'm not familiar with them doing that. We've actually been establishing guardianships on a number of Brookwood long-term residents. My impression is that they don't want that responsibility, but I would check with them directly.
And I would say that as well, and I would say it's just not everything's the same. So you might check with one place and another place does it differently. There are a lot of places throughout the United States, throughout Texas, and what they do and don't do are very, very different. They're different companies and they operate differently. So I think that's good advice.
Just a small plug on Brookwood. They are kind of the gold standard for long-term residential care for our loved ones. There's actually a new Brookwood facility in Georgetown, Texas. Brookwood in Georgetown, big. That's where my daughter is resident, and she just moved into the first women's house that they opened up in January. And so that's her final permanent nest, we think. It's modeled just like the Brookwood in Brookshire. Their public facing adventures are going to be slightly different. They're going to have a miniature golf course and a pet resort. And my daughter especially is looking forward to working with the dogs and the puppies. So,
We've heard a lot of nice things about Brookwood and Big, and I know, guys, if that's of interest to you, of like residential living places throughout Texas, we have done multiple webinars on residential living, places throughout Texas, and we kind of did like a speed dating. Each of the facilities comes on and says who we are, where we're located, who we serve, do we have openings, how much do we cost, basically in the course of an hour. So you'll want to look at the panel webinar. It'll be called housing or residential housing panel webinar. So you'll want to check that out. So let's talk about the guardian of the estate.
sure. So guardian of the estate, this is the one that's intensive, requires court review of everything that occurs. There's an annual accounting that you have to go back to the previous screen. There's an annual accounting where you have to go in with receipts to the penny at the end of the year. Inevitably, you will have spent money out of your own pocket that should have been spent out of the ward's estate. So you'll be asking for a reimbursement out of the ward's estate. Inevitably, you will have spent money that was off budget. You'll have a monthly budget for your ward, but there are things that come up. And inevitably, you will have spent money that's off budget. And at the end of the year, we turn in all those receipts on an application for ratification. So the guardian of the estate is the one that's pretty intense. Now, on the next slide, there are some alternatives to guardian of the estate. One of those is on the next slide. One is a benefits representative payee. So if there are federal benefits that they're receiving, either SSDI, RSDI, SSI, any of those sorts of things, the federal government has their own way of vetting to see if you are the appropriate person to receive the benefits for this person. And then you do an accounting to them. Because you're accounting back to the federal government for what you're doing, the guardianship court doesn't require you to file with regard to those benefits. Also, they recently changed the law that if your ward comes into money less than $20,000, the guardian of the person can manage those funds without establishing a full guardianship of the estate. I think there's still a couple of court filings involved. It doesn't come up very often, but if it does, that is an alternative to creating a full guardianship of the estate. If money does come into the ward's name and they're under age 65, there's always the possibility of setting up a party special needs trust. And so maybe grandmother dies and leaves $100,000 to Emily. That's more than the board can manage. We don't want to, than the guardian of the person can manage. We don't want to establish a guardianship of the estate. We can pop it into a first party special needs trust, and then it doesn't count. And it's managed on her behalf by the trustee. If Emily has a small job and she's earning a few dollars a month, ABLE accounts are great for that. There's a limit tied to the annual gift exemption limit. So this year it's $19,000 of how much can be put into an ABLE in any one year. But for the kind of small jobs that a lot of these wards have, that's perfect to accumulate money in. And it can go over the $2,000 limit if they're on Medicaid or SSI. It doesn't affect their benefits until it accumulates to more than $100,000, which is a long way off. 1301 Management Trust, basically it's just like guardianship of the estate, except we turn it over to a bank or a trust company that's in that business. And they can manage the ward's assets. They have a streamlined ability to do things. If I'm Emily's guardian of the estate and Emily owns IBM and I want to buy Xerox, I have to get court permission to sell the Xerox. I have to report the sale. I have to get a confirmation of the sale, and then the sale can occur. And then I have to go through a similar process to buy the Xerox. The banks and trust companies, they just do it and then report it at the end of the year. Community administration is one that's often overlooked. This is for older adults that are married, especially if they've been in a long-lived marriage. So Frank and Sally have been married for 42 years. Frank develops dementia. and Sally wants to administer the estate, she can become the guardian of the person and community administrator and does not have to open up a guardianship of the estate on Frank because it's all community assets and she's the community partner. And so she manages all of the community assets. And there is some of the courts love this and some of the courts hate it. The reason they hate it is there's no reporting required by Sally. She's just empowered to do anything. The only negative on community administrations is that third parties don't always know what this is. And we have to beat them over the head sometimes to allow Sally to do what she needs to do. So those are alternatives to guardian of the estate.
I just want to mention here because I think there's some confusion. Some states, so if you've moved to Texas from another state, they automatically do conservatorship and guardianship of the estate at the same time, like guardianship of the person, guardianship of the estate at the same time. A lot of states do it that way. Texas does not do it that way. So if you have guardianship of the person and you're like, oh snap, I should have guardianship of the estate in Texas, you probably don't need it. And when you have a special needs trust, I mean, you could have $10 million in the special needs trust and not need guardianship of the estate. It's outside of those vehicles of the special needs trust and the ABLE accounts. Is that right, Bill? It's kind of
Exactly.
confusing because other states do it differently.
Exactly. And so when we're doing estate planning for a family to begin with, we talk, and they have a special needs child, we will talk to them about who's going to be the guardian nominee to follow them after the parents are not there. But then, even though we want to set aside resources for the benefit of the special needs child, we never give we put it into a supplemental care trust for the benefit of that child. We don't leave the assets directly to the child. We put them into a special needs trust for the benefit of the child. I use the term special needs trust and supplemental care trust sort of interchangeably, but it's a third party trust. There's no Medicaid payback provision. The assets from mom and dad go directly into that trust for the benefit of Emily, and there's no court reporting required. And so that's a wonderful alternative to giving Emily assets and then having to create a guardianship of the estate. That we avoid that if at all possible.
Someone wants to know who reimburses you if you spend out of your own pocket.
It comes out of the ward's estate, assuming that there's money there. It's not going to come from the court or anybody else, but it comes out of what we're saying is it should have been an expense paid for by the ward's estate out of their funds, but you paid for it out of your pocket. You can get reimbursed from the ward's estate at the end of the year.
Okay, and then otherwise, when it's coming from a trust, reimbursement from the special needs trust, the
Yeah,
trustee would make that reimbursement. And then
correct.
the last question we have before we move on is, and this is a great question, how do we evaluate which bank would be best as a trustee or a guardian of the estate? They all want money, and that's true, they all do want money, but I do have some opinions on that. I'm sure you do too, as far as the banks that are better at being a trustee for a special needs
Sure.
individual.
A lot of it comes down to the individual trust officers. Some of them are more dedicated and swift in this area than others. Some of it is the institutional predilections of the banker trust company. We've got 3 or 4 that we work with frequently. A couple of those kind of fallen off of our radar due to the loss of people that the trust officers move on somewhere else. And so their fees, my experience is the fees are generally pretty well aligned because they're in a competitive business. So you're not going to necessarily be picking a bank or trust company based on fees, but you do want to talk to the trust officer that would be assigned to the case. And are they talking your language? Are they explaining things as for you to understand them? And most of them will be quite happy to have you continue to be involved, have the family continue to be involved with Emily as much as possible. But even though they're going to be managing the money, and so can you establish a good working relationship with this trust officer? Do you have a sense of rapport with them? Does it feel like a good fit? But it's kind of fuzzy in terms of actual evaluation. It's who are you comfortable with?
And I've not seen, I have people ask this question all the time since we're on it. I'll just say, I've not seen ever a bank or an institution. We have 3 or 4, and you're right, there has been some movement of folks. But I've not seen any of those banks draw a line in the sand of, we guarantee that the fees will never be more than this.
No,
Like,
no.
because if you do this in 2025 and it's 2070 now, like they're not going to do that. So I just want to save you guys the path of looking all over high and low for that. 'Cause I've never seen that. I don't know if you have, Bill.
No, 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 they'll never do that. And they always want it stated that their compensation, if it's a trust, for example, they want their compensation to be stated as customary and reasonable, based on their current fee schedule. So one of the things, if we're dealing with a trust, like a special needs trust, one of the things that we often do is include language about trust protectors, probably a better word for that, but somebody who can monitor the situation and change trustees if appropriate. So if we go with one of the local banks and their fees get really out of line, somebody has the ability to change that to a different bank. And so looking at how we keep some control over that and keep a check and a balance on that in the future, that's part of the design of that special needs trust. Um, um, Well, to look at others, as we mentioned earlier, we look at other supports and services besides guardianship. Does this individual have the capacity to execute a valid financial power of attorney, medical power of attorney, and HIPAA? Can they do a supported decision-making agreement? We're going to always, and the courts are very intent on looking at that and making sure that those have been considered. So next slide would be typical process. So consider the alternative supports and services, get the doctor's letter, um, the court filing to initiate the guardianship process. Now, a lot of times this is coming up in terms of children that are turning 18. We can actually file up to 6 months prior to the child's 18th birthday. We can file the guardianship proceeding with the court. The doctor's letter has to be dated within 120 days prior to when we file. But then the filing itself can be 6 months out. We can't actually have the hearing until the child turns 18. But we've actually arranged it sometimes to do the hearing on the 18th birthday. But it usually comes up a few days after. So we get we consider the supports and services, the doctor's letter. A lot of times that should probably be the other way around. Get the doctor's letter first, see whether this person has the capacity to execute powers of attorney, or whether guardianship is our only alternative. Initiate the filing process. 3 people will come out and visit the proposed ward. A constable in uniform will come out and serve them with papers that the guardianship proceeding has occurred or has started. A court visitor, somebody that's on the court staff, a court investigator, sometimes they're called, will come out and talk with the proposed ward and the family. Sometimes they do that in person. Sometimes they do that by Zoom. They're making an initial assessment on behalf of the court of whether this case actually is appropriate for the guardianship process. Judge Austin, who used to be the judge in Probate Court 1, told me years ago that he washed out about 30% of all the guardianship filings because people stumbled into the system without really realizing what they were doing. I don't think it's quite that high these days because there's a lot more procedure around it. But nevertheless, the court visitor is going to do a quick and dirty on whether this looks like it's a good case for the guardianship process. Then the attorney ad litem is appointed to represent the proposed ward. The attorney ad litem is Emily's attorney. I filed for guardianship on Emily. An attorney ad litem was appointed to represent her. The attorney ad litem's role is to zealously and vigorously defend the proposed ward against the guardianship. Now, what does that mean? That means that if Emily is presenting pretty well the day the ad litem interviews her, the ad litem may ask for an independent medical evaluation. He also wants to make sure that the proposed order that we're giving the court to sign is no more intrusive than absolutely necessary, that it conforms exactly to what the doctor's letter said the deficits were where she did not have capacity. Also, the ad litem's role is to make sure that the right person is being appointed as the guardian. We've had several situations, oftentimes with older children, young adults, where there's a lot of baggage built up in the family over the years, and they're very, very, very reactive to mom. For right or wrong, they're just very reactive. And having somebody else serve as the guardian might be a better alternative. So that's something that they consider. Once the ad litem is confident, has done their homework and they're ready to go, then we can have the hearing. At the hearing, the guardianship is established. The and then we're into the issue of the guardianship letters and doing annual reporting. What is not on this list is making sure that the proposed guardian is ready to go. They changed the rules a few years ago, and now the proposed guardian has to register with JBCC, Judicial Branch Certification Commission. They have to do some online registration of themselves and the proposed guardianship. They have to submit fingerprints. There has to be a DPS background investigation. They have to do online training. Now, one of the questions that was sent in ahead of time was whether when parents are not U.S. citizens, should they get somebody else to be the guardian? Depends on legal status. If you're here on a green card or are legally in the country, there's no hindrance to you becoming the guardian. If you're undocumented and have if you're just an undocumented person, you may want to think twice about becoming the guardian, because going through DPS and providing them with fingerprints and background information, I'm not aware that they currently have any action with ICE, but that's probably a moving target these days. Have you seen anything on that, Allison?
I haven't seen anything on that, but what I wanted to ask about, it looks like I'm freezing. I'm gonna, oh, it's better now. Um, I wanted to ask because I know that people have to be served, and that's part of the process. People being served, siblings,
Mhm.
adult siblings get served, ex-spouses, the estranged parent, all get served. What
Yes,
if there is an estranged parent that A, lives out of the country, or B, we literally have no idea where they are? Because that is something that people ask me every single year. I have
right.
multiple people ask that. What
We,
do
we
you do
can
in that example?
we can report those facts to the court of what our attempts have been to serve the person, and ask for permission to do substituted service, which is usually a newspaper notice in the county. Um, so there are ways to get around that when we just can't find them.
Okay, gotcha. And then the other question that comes up, and I know you hear this one all the time too. What if there happens to be a divorce situation and one parent is adamantly against guardianship, the other parent is for that? How does that work? You
Well, it's going to turn on the medical evidence. So the only vote that either parent got was whether to initiate the process. Once the process is initiated, it's going to go based on that doctor's letter. And if the doctor's letter says there's at least partial incapacity and there's no supports or services that are a good alternative, a guardianship will be established. And so the parent may be adamantly opposed to it, but the court is going to go with the medical evidence.
Okay, I want to ask a question that comes up too, because in the spirit of least restrictive, most appropriate, over the last couple of years, I've actually seen some things that maybe like a power of attorney, a healthcare power of attorney, a supported decision-making agreement is in place, and clearly the individual does not have capacity at all, didn't have capacity to understand what they were signing. Our kids are going to sign anything that you tell them to, most of them anyway.
Sure. Yeah.
So what is, I want you to talk about the dilemma in the example where a person, obviously a power of attorney, healthcare power of attorney, supported decision-making agreement's cheaper than getting a guardianship. And some people go that path. And I'm not against that path if that's the right path, because we can always do something more restrictive. But in the example that it is slam dunk the wrong path because the person doesn't have the capacity, what are things that can happen as a result of that? Like, like for example, we had a client that all that those documents were denied at a hospital. They basically said the kid never had a capacity to begin with. They don't have capacity now. They didn't have capacity before. So
Right.
can you just talk about that? Because I don't want families, if
Sure.
it is in a situation like that to get in a bind like that?
So historically, it was very difficult to make third parties accept a medical power of attorney or a financial power of attorney. They changed the law a few years ago that if you present a power of attorney and a third party is going to reject it, they have to give you something in writing as to their reasons why they're rejecting it. Bottom line, though, if the doctors are not cooperating and aren't going to accept the power of attorney, I'm not aware of how to force doctors to do that. If you're dealing with a third party like a bank or a trust company, then you could probably show cause them into the probate court into the guardianship court as to why they're not accepting the power of attorney.
But
But I'm
bottom
not
line
aware that
is a court order, it's not quick, it's not
yeah,
cheap,
yeah,
and
no,
you don't want to get, you want to make the right decision on the front end is my suggestion, because a court order and somebody's health could be hanging in the
yeah,
limbo. Like there's a lot of reasons not to do that, and it starts getting slippery. And there's been cases of that you guys have seen online of other states and things like that. So that I just want to indicate that it is
sure,
important. And I think one litmus test that I think of, Bill, is can they do activities of daily living? Can they feed themselves, get in out of bed, toilet, transfer, bathe? Could they make their own appointments? Could they get themselves to appointments? Can they handle finances? There's a lot of things. Or if you don't even think about all of those things, is if I died tomorrow, could this kid handle themselves?
right,
And if the answer is no, then maybe you need to have a deeper conversation about partial guardianship or guardianship. Because if you died tomorrow and they're left to their own devices, would that be a problem? We had somebody that called us. He was actually a cousin. The cousin lived in California. The individual with the disability lived in Texas, and mom and dad died, and the individual was not under anything, but clearly didn't have capacity and had nobody else, and so it was living by themselves in a house, couldn't handle things. I mean, it was a real that was messy. They got it all cleaned up, and it was ended up happy ending, but it was really messy, especially if somebody's trying to handle stuff from another state.
well, this goes back to something else I think that you've spoken about in the past, which is if absolutely nothing else happens, if you have a family member that has some disability, write a letter of intent that kind of gives the person who's going to step into your shoes to take care of them a running start on understanding what's going on with them, what works, what doesn't work, what you've tried, what you're expecting in the future, etc.
We've done webinars on that for anybody that hasn't heard the letter of intent. We have a template for that. We'll be happy to share that with you. And to me, those go alongside your legal documents. It's nice to have that along. I always say that I've forgotten more than anybody will ever know about my kids. And I just do it. It's second
Yeah,
nature. It's what we do. It's what you do. But
yeah,
somebody else doesn't know that. So having that down is going to be really important. Thanks for
sure.
talking about that, because I think, and it's not anything. All this stuff is not anything to scare anybody. It's just looking at both sides, because it is a broad term, the least restrictive, most appropriate. But the key word in all of that, sometimes some would say it's least restrictive, but it is still most appropriate.
Yes.
um, and so I think sometimes there has been lost sight on the most appropriate in some examples where it has been detrimental to the individual with a disability.
Yeah. This current slide is important because if you believe that somebody needs help, that a guardianship may be appropriate, you're not sure, you don't really want to make that decision, you can write a letter to the court and give them all the information that you have, and they will do their own investigation and initiate a guardianship process if appropriate. There's a form for that that we can provide to anyone who's interested. The requirements for that are laid out in the statute. But you don't necessarily have to initiate the guardianship yourself. You can just refer it to the courts, and they'll investigate and determine whether it's appropriate. On the next slide, yes, boards do have a Bill of Rights. I think they're the 2 or 3 pages of rights that they have that they have to be provided with, whether they understand or not. And it's something for the guardian to review frequently to understand what it is. And then who has priority? Uh, if they've done a pre-need designation of guardian, for instance, if I'm doing estate planning for an adult, one of the documents we do is who do they want to be their guardian if in the future they come up with dementia or Alzheimer's or something. So that person has priority. After that, it's as you might expect, spouse, adult children, parents, sibling, or any other interested party. Um, that's pretty much a quick overview of guardianship. Are there other questions? Anything at all?
Bill, the question of the day always comes up of the average range and cost of guardianship. Can you just give us a range? And I just want to preface what he's saying is all firms are different. Everybody, all attorneys that do this charge differently. But I think that there is a range for non-contested guardianship. And then when you start getting in contested waters, then it starts getting real expensive real quick. But tell them a range that they could plan for
Sure.
financially.
So for an uncontested guardianship, it depends on whether it's guardian of the person or guardian of the person in a state. But guardian of the person in a state together, you're in the range of $5,000 to $6,000. Guardian of the person is less. Now, again, as Allison says, if it becomes contested, then the sky is the limit. And especially if it's a divorce situation and both parents think they should be the guardian, they're relitigating the whole marriage and everything that's ever happened.
The bottom
Uh,
line, anything contested when it comes to attorneys, it's expensive. That's the bottom
yes,
line. It doesn't even
absolutely.
matter what the matter is. If it's contested and there it's
And
attorneys and court, it's expensive. That's the
and
bottom.
we don't go anywhere near contested litigation. We only do the uncontested. There are people out there in the world called probate litigators that love doing that kind of stuff. We're not them. So
And so somebody said, is there an attorney in West Texas that we recommend? I do think that we have one on the list, but the bottom line is, for guardianship, usually the attorneys work by county, in as far as guardianship is concerned, and not over the whole state. Do you guys have a broader county range, or do you stick to Harris, Fort Bend, Wharton,
we
Brazilia?
actually we generally stick with Harris County and the surrounding counties that touch Harris County. We occasionally do things in other counties if they allow us to do Zoom hearings. During COVID, we could do Zoom pretty much anywhere, and so our range expanded. A lot of the counties have gone back to now requiring in-person hearings, and so we've drawn back into just Harris and surrounding counties as a practical matter.
Sure. And you guys can reach out and, we have an attorney recommendation list. Of course,
Yeah.
we recommend Hayes and Wilson all the time and have for years. We've kind of talked about a lot of stuff, but I hope that you walk away from this meeting if you've been thinking about guardianship, alternatives to guardianship, and I hope that you know more and you feel better, you feel less anxious. It is a big deal. It is a big deal, and especially, the physician statement, it's all right out in front of you what your loved one is not able to do, which is not exactly what you had in mind for them, right? And so there are emotional, thoughts that go into this, a lot of emotions that go into this. But again, the team that you're working with and the attorney team, they're here to guide you and guide you appropriately. It's not in stone forever. It might be what is most appropriate right now, and that might change in the future. So you guys will have options there. We have, our Consolidated Planning Group YouTube channel. I mentioned earlier, all of our past webinars live on that YouTube channel. If you can think of the topic, it's probably out there. We really aim to go through the topics that are common to the families that we serve all the time, the things that come up all the time. And I brought up a lot of the questions that come up all the time today too with Bill. Everybody is going to get a copy of today's slides and a link to the recording. It'll have a link to our upcoming webinars where you can register for future webinars going forward. This is our QR code. We always offer free personalized consultations. So whether you've done a lot of planning and you want a second opinion, you've done a little planning, and you need to pick up where you left off, or you just need to get started, we can meet you where you are on that. That QR code will take you to our calendar where you can schedule that free personalized consultation. So, Bill and Rowena, it has certainly been a pleasure being here with you both today. Thanks for providing such great information, Bill. And I think I know all three of us have kids with disabilities, and I think part of that, I don't know, it's kind of my opinion as a parent. I like working with professionals who get it, who get where we're coming from. The three of us before this webinar started, we're talking about real world times, and some of those things, and we know all of you have those as well. So we do absolutely get it, and we want to help you on your journey. So thanks, everyone. Certainly been a pleasure, and we'll look forward to connecting with all of you again soon.
Thank you.
Bye now.
Bye-bye.